My Lady, my Lords, can I, we've reassessed our position, and can I set it out like this? Ground 3 is related to level of representation at trial. Permission was granted in its original form, but has expanded since then, and we'd simply ask the board to consider that on the papers. We make no further oral submissions. Ground 4, relating to the good character direction, we abandon. We won't seek to argue that. Ground 5, which deals with the judge's approach and directions on the identification of the registration number, we require permission for that. I would invite the board to consider it mainly on the papers, but I would seek to make 2 short submissions on that point. And then ground 6, again, which we need permission for on prosecution impropriety, we would invite the board to consider that on the papers, no oral submissions, but there are 2 additional references to the prosecution speech. I would simply invite the board to do that. So, my lady, if it's acceptable, I'd simply like to deal very briefly with ground 5, which this was one of the central planks of the prosecution case. And my lady, my lords, it's at appellant's case 1077, paragraph 172. One of the central planks of the prosecution case was that there was identification evidence which purported to identify the appellant's truck, pickup truck, about 3 minutes away from the scene of the murder at about the time. The prosecution relied on this heavily, and the main witness was Aquila Rawlins, who, when she gave evidence, there were, in our respectful submission, clear weaknesses which were not helped and were exacerbated by the fact that trial counsel failed to properly cross-examine her. But when she was asked if she could describe the pickup truck, she made no response. She described the circumstances that the light was on in Fiefield's house and she had no difficulty seeing the number. Prosecution relied on that, saying there is light, she gives you the number, she is in no doubt. However, Mr. Fifield stated that his lights were not on. The matter was confused further by the fact that, having failed to challenge the witnesses, other than asking a few investigatory questions, trial counsel put it in his closing that she'd imagined it and that she was lying. The judge's misdirection in our submission is that, first of all, she failed to remind the jury of the factors which would have affected the reliability of Aquila's evidence. Namely, there were other vehicles in the area, she wasn't able to say how many, and crucially, that she does not remind them that there's a clash of evidence between her saying the lights are on, which assisted her in seeing the registration number, and Fifield saying they were off. And in fact, it's made far worse by the fact that Fifield's evidence isn't summarised at any point in the summing up. The final point that I would make on this ground is that the judge then goes on to direct the jury that they have to be sure about the credibility of the witness. I accept that the judge was in a very difficult position because Dr. Brown didn't challenge the witness as either being a lie or generally unreliable. Although, excuse me, in closing, he said it was a lie. But my lady and my lords, in those circumstances, it would be fair for the judge, in my respectful submission, to put before the jury all reasonable factors and explanations that arise from the evidence. And as with all evidence, it's clearly both a question of credibility and reliability. And that reliability should have been left to the jury to consider in addition to the credibility point. My lady, finally, in terms of the prosecution impropriety at ground 6, I don't make any further submissions on this, but I would ask the board to note 2 additional references where we say that the prosecution counsel expressed his own opinion of the appellant's guilt, and that is at page 699, line 21 over the page to 700. He says all the evidence points...
699.
699, my lord, yes, in the record. 699, final line, and then over the page, all the evidence point to him and no one else. There is nothing I can think of that would come to its aid. And then finally, on page 703, line 9, guilt of the accused is charged for killing his wife in a most brutal and savage way for the reasons which seemingly make no sense to any of us as men and women of the world. And then one very minor matter, which is a correction, which is that at paragraph 209C of the appellant's case, at page 1085, the assertion there that... Sorry.
This is the dog that didn't bark.
The dog didn't bark is wrong. It's... Mr. Brown said that the dogs did bark at him, so we no longer rely on subparagraphs, so I simply say that for correction. My lady, my lords, unless I can assist you any further, those are my submissions. My lady, I don't know whether you wish me to deal with the question of proviso now.
Maybe.
Not now, I don't think.
But wait until we've heard from the respondent.
Thank you, ma'am.
Thank you. Ms. Jones, you follow? Yes, Ms. Dowd.
I'll be very brief, my lady. I intend to look at the bad character evidence, and I think this court must ask itself whether the evidence that was led by the prosecution was relevant evidence. And my learned friend seemed to have lost sight that when the appellant first spoke about the incident which had, he told not one, but 3 persons that someone else was responsible for her death. As a matter of fact, the reason why he was taken, well, the large part of the reason why he was taken to the hospital and taken by the security was that he intended to go and find this person who he claimed was responsible for the death of the deceased. This evidence was necessary to rebut the suggestion that someone else had killed the deceased, not the appellant. It was necessary to show the background relationship of the appellant with the deceased. It was purely incidental, that it included acts of assault. And when you look at it, when you examine it very closely, my lady, no one witnessed any assault between the deceased and the appellant. And the witness merely gave evidence that there were admissions on his part of assaults.
Well, yes, but that's right, of course, but the admissions were relied on as being truthful, weren't they?
Yes.
They were relied upon to prove that there had been assaults.
I would submit the admissions were relied on not to show propensity, but to show that all things was not all well and good with
To show the relationship.
Yeah, show the relationship of the parties.
Yes, but it was the admissions, it was the facts that were admitted that showed the bad relationship.
Well, let me put it this way. My learned friend stated that there was other evidence, but there was no other evidence. Those two witnesses were called right at the commencement of the trial. Witness number 1, witness number 2, Odette Weeks, and Yvonne. And the appellant, in the interview that he accepted was correct, denied knowledge that that she was about to divorce him in his interview. He knew nothing of the divorce proceedings. It was clear that both of them were not living together, and he himself introduced in his interview evidence of an event that almost got him in trouble down at the Four Seasons Hotel. Three weeks before her death, I accept that evidence of bad character is not generally admissible, but in Maya's case, I would wish to remind this court that Lord Herschel also said in the Myers case, and this would be at paragraph 39, on the other hand, the mere fact that the evidence adduced tend to show the commission of other crimes does not render it inadmissible if it be relevant to the issue before the jury, and it may be so relevant if it bears on the question whether the acts alleged to constitute the crime charged in the indictment were designed or accidental, or to rebut a defense which would otherwise be open to the accused. My submission is that it was relevant to rebut the suggestion made by him, planted right at the onset, that someone else tried to kill, was responsible for killing the deceased. And these categories are not closed. It is not an exhaustive list. As long as I have been practicing, and insofar as historically my knowledge of cases, evidence of this nature has always been admitted to show that the deceased death did not happen accidentally or by a stranger, but given the relationship between the parties, there was a need for the jury to investigate whether the deceased died at his hands. It is also evidence of motive, my lord, possible motive. And I've set it out in the appellant's case from paragraph 33 to paragraph 45 in the respondent's case. And I think it's sufficiently set out. Motive is at 38. I do not think I should trouble your lordships by repeating what I've said here, unless you want me to elaborate on anything.
As far as I'm concerned, no, there's no need to elaborate.
There's no need for that.
Well, but my lords may have matters they want to put to you.
In relation to the ground that...
it does, would you accept that the prosecution counsel went a little further than the role that you suggested? I mean, he talked about this being a picture of a husband who had an uncontrollable temper.
Yes, that was at the onset. I accept that. He said so at the onset of the trial in his opening statement. And I really can't speak for him. Different council have different styles. And I put it as classical exuberance on his part.
But you put that very
Yes.
attractively in our case.
Should we treat 659 the same, do you suppose? Just have a look at 659.
659? Yes, my lord.
This is closing speech. Line 9 onwards. Women don't get married, nor men to break up, nor do ordinary difficulties push reasonable people out of marriage, etc., etc., etc. Where there should have been love and affection, she was getting humiliation and hurt.
I don't believe.
Where she should have been getting tenderness and support, she's been getting abuse, physical and verbal. He's making a case in the matrimonial dispute.
It sounds so, my lord.
It does.
It does. It's unfortunate. But in my submission, that is not sufficient to rule that the evidence should not have been led.
Well, he does go straight on to say in the next page.
Helpless inclination to beat.
Yes.
Well, no, but also the fact that there's a history of violence doesn't make him guilty of murder. So, I mean, it is to some extent balanced, but is there any sign of anybody having applied their minds to the question of whether what was being adduced served the purposes that you now say that it serves?
I mean, the most I can say is that Nevis is a very small community.
Quite.
And matters of this nature would always be in the public forum.
Notorious anyway.
Notorious anyway.
Well, that may be.
It's very small. The appellant was a well-known cricketer.
Quite.
So in some sense, he was a public figure. And then both parties were employed at the biggest and best hotel in the Leewards. I put it in the Leewards, short of Curtin Bluff and Jumbie Bay.
Yeah.
And it's a notorious fact. People knew it.
Well, that may be, but
he went overboard.
You really have got to demonstrate, you know,
Yes.
that somebody has thought about when evidence is admissible and when it isn't.
Yes. He definitely went. I must agree that he went. He overboarded with his comments.
But does that not mean it was incumbent on the judge to give a direction to bring the jury back into line?
Well, the judge was very trenchant. She said, this background evidence doesn't mean that he did it. She was very trenchant. She said, the fact that there was a history of violence in the relationship does not make him guilty of murder.
No, that's not the judge. That's counsel for the Crown. What she says, I think, is at 819.
Oh, yes. They have given you also a lot of background to the relationship between the accused and the deceased, and that is not relevant to the offense as to convince you that you feel sure he committed it.
Yeah.
What you have to find is the ingredients I pointed out to you that you must find. And those several ingredients, my lord, she was very astute to remind them that it is the duty of the prosecution to prove the case.
She certainly says that. She also, at 823, goes through what are effectively the strands of the case, which does not include the matrimonial history. Anyway, you say 819 is enough, do you?
Well, it is the conclusion which she drew, having gone through the strands of the matrimonial history. At the end of it, reminding the jury, this was evidence that was before the jury. This evidence does not make him guilty of murder. It is not relevant to the offense so as to convince you that you feel sure that he committed it. I don't know what else the learned judge could have said to the jury. I cannot even hazard to guess.
Well, I would have thought it's quite clear what he might have said to the jury. And that is, as Mr. Taylor set it out in his case, and also she could have said, A, that it is relevant for understanding the relationship between the accused and the deceased, and B, evidence of propensity. It cannot be used to reach conclusions about propensity.
Yes.
And
Well,
she didn't say that.
You'd say, wouldn't you, something like,
you'd say something like that. Yes,
you can't just tar the man with the reputation of being short-tempered and say it follows from that he committed this offence.
No, she said he did. It does not. It is not relevant to convince you that he committed the offence. Yes. She's saying to the jury it is irrelevant in convincing you that he committed the offence. And I don't think it was the propensity part. In my respectful submission, was in my mind was incidental. Incidental to the behavioral pattern between himself and his wife.
But I mean, what she said cannot help you. What she said, that is not relevant to the offence as to convincing you so that you feel sure he committed it. If it's not relevant to the defence, it shouldn't to the offence, it shouldn't have been admitted. You say it is admitted. Once it's admitted, then one has to indicate for what purposes it's admitted, and that wasn't done.
I can't argue that. I have to concede that.
I wonder if she was being overly favourable to the defence, actually, in saying that it wasn't relevant to the offence. I would have thought her history of violently assaulting your wife was highly relevant if you're on a charge of murdering her.
Yes, that is also true, but what I'm conceding is that perhaps the learned judge could have gone a little further and point out to the jury the reasons why this evidence was led, why it was necessary in the circumstances. In any event, there was abundance other circumstantial evidence which could have satisfied the jury that he is the person who committed the offence.
Is that a proviso argument?
I'm not supposed to speak to the proviso at this point in time. No, my lady, could I deal with a killer?
Yes.
Yes. The point is very short. A killer and her mother were never cross-examined by defense counsel as to their ability, one, in the case of the mother, to see that there was a red pickup truck parked in the gap leading to Five Fields' home. Secondly, a killer ability to discern, see what was the registration number of the red pickup truck that was in the gap. The only time bushes came into play is through the exuberance of, I would put it, of counsel, the prosecution counsel. I don't know why the judge permitted him to ask the questions, but he brought up the subject of bushes in re-examination. Didn't strictly arise. Where's my thing? I'll find it for you, my lord. It's at page Killer Rollins. Examination in chief. It's 3 minutes walk. Isn't that she and her?
I think it did. 183.
Yes, 1883.
First question in
She said,
cross-examination.
this alley had a lot of bush in it. Yes, ma'am. Do you know the alley well, don't you? Yes, ma'am. As far as you are concerned, it is quite difficult to go through there after sunset. And I don't understand the question. This did not arise from cross-examination.
Well,
And with respect to counsel, there seemed to have been some confusion between the alley and the gut. They were two distinct things. The alley led to Fifield Home, and you have to pass Olivia Williams' house, and Fifield, in unmistakable terms, said that there was a light next to Olivia Williams' house that shone at the entrance of the gap leading into his house. It was, part of the entrance was a bit dark because of the trees on that side, but on the left side there was light. No one bothered to explore whether the vehicles were parked on the left side or the right side, or how close the vehicle was to the main road, or on which side of the main road Aquila and Malvo were traversing, walking. And it was very evident that Aquila was much more observant than her mother and more alive. Both saw a red pickup, but Aquila saw the number of the red pickup. Both saw the lights of the car on, of the deceased car on, and the horns blaring, but Aquila saw movement, the car moving sideways from side to side, and she also heard a woman's voice in the car. And my Lord, let me see this. If someone were to come in here at this point in time, and God forbid, shoot me, none of the witnesses in here would give an accurate account of what actually happened. They might say the assailant was wearing a hat while he was bald-headed. They might say he had on a red shirt while he had on a blue shirt. These things happen. Your mind, your brain, its perception plays tricks, these little tiny tricks in you. So I thought the gratuitous comment by the defendant counsel that Aquila and her mother passed like an idle wind was designed to say, oh, never mind that, man. They were passing, they didn't say anything, basically. Because he never put to her that she was lying. He never put to the mother that she was lying. This evidence was unchallenged. Unchallenged. And I did submit that the judge correctly, in those circumstances, directed the jury. Yes, I know at 10 years later or 9 years later, in hindsight, when we were busy dissecting the corpse of that case, counsel of varying expertise would say, oh, you could have done this and you could have done that. But it always happens that way. She told them at page 44, at page 824, you have the defense saying Aquila Rollins is not a witness to believe. Basically, it is for you to decide as to her credibility. You must decide whether she was telling the truth, because if you believe she was telling the truth, that is a significant part of the prosecution case. In relation to Aquila and every other witness, it is for you to accept the truthfulness of the witness. She also reminded them that this is in the realm of different witnesses seeing different things and noticing different things. We all have different powers of observation, and that's in my view, is a correct way to approach this evidence. It was hard. It wasn't challenged. Hardly challenged. Counsel can say what he likes at the close of the case, but he should have had some evidentiary foundation on which to ask the jury to treat it as passing like an idle wind. I don't think I can help your lordship and ladyship any further. I would hate to tarry on your good nature.
Well, in terms of time, you're doing extremely well, Mr. Hamilton.
Yeah.
You have lots of time in hand.
I have lots of time, but my friend did make certain concessions. But if there is anything that I can help this court with, I am willing to try, at least.
I'm just making sure. It appears not. Thank you very much indeed, Mr. Hamilton. Thank you. Mr. Graham, do you wish to add anything?
Nothing to add.
Lady, my lords, just briefly, in terms of bad character evidence, the proposition that this was to rebut the appellant's suggestion that there was an alternative suspect, that of course wasn't the way it was relied on at trial. I deal with this at page 1193 in my supplementary case, which seeks to respond to my learned friend's case. It was raised once in the evidence my learned friend's just referred to, when just after he'd been told of his wife's death, when he was asked in the interview whether there was anyone else who he thought may be responsible, he said no. Sorry, can I find the exact part? Yes, I'm so sorry. It's a paragraph 15 of my case, letter A. Do you know who killed your wife, Shermell Phillips? No. Do you know anyone who would have a reason to kill your wife, Shermell Phillips? No. So it wasn't the basis of cross-examination. It wasn't raised again, and it certainly wasn't put to the jury in the prosecution's closing speech that this was the reason that the evidence was called. Just to correct two factual issues that my learned friend made. The first is that he said the reason he was being taken to hospital was because he'd made this allegation. That's not correct. The reason he was going was, according to at page 314, the witness said, I thought that he may have needed some medical attention. Well, yes, seeming he continued crying and was a little distorted. And then down the page, after line 13, well, I told Gary to give him a ride to the hospital, and he agreed, but he asked that one of us go with him to assist. So it simply wasn't correct to say that this was because he was pursuing the alleged suspect. In terms of, my learned friend says that when it was put to him in interview, he denied that she had filed for divorce. Well, in fact, page 16 of the record, about 10 lines down, are you aware that your wife had filed for divorce? And the answer is no. So it's not a denial. But in any event, we submit that it's a wholly, with respect to my learned friend, unmeritorious argument to argue that this was put in for that purpose when it makes no appearance in the prosecution's speech at all. In terms of the point my Lord Hughes said in referring to the prosecution's comment that the bad character isn't relevant to the, it doesn't make him guilty of the matter. And I think my Lord used the term, it was balanced to that degree. Well, with the greatest respect, it seems that where the prosecution's speech has said, used the words, it emerges, the picture that emerges is of a husband who has an uncontrollable temper, and then later on it's a helpless intonation to beat, seemingly be bad, and where the judge doesn't deal with it. And finally, the factor that when one looks at the judge's summing up at page 767, there is at least an invitation that the jury can follow and accept the views expressed by counsel. Because at line 5, at the top of the page of 767, the facts of the case are entirely your responsibility. You would have heard the addresses coming from prosecution and the defence earlier. They would in each case have given their views on the evidence. You are not bound to accept those views unless you agree with them. Well,
That's absolutely standard direction, isn't it?
it is indeed.
Yep.
The
No, I understand what you say about its effect, but it is absolutely standard.
Yes, and I think there would be a complaint if it hadn't been made. But certainly, in the circumstances of this case, the danger arises that what was put out with all good intention actually opened up to the jury the impermissible use of these. In terms of motive, I've dealt with that again in the supplementary case. In terms of the identification evidence for Quilla, just a very brief point. Of course, the question here for the jury was, could they be sure that her purported identification of the registration number was accurate and reliable? Now, the only way that a witness can give that sort of, or the jury can analyse that sort of evidence, is looking at the context in which it was given. And where identification, I accept it's not a Turnbull case, but where identification is given of something that the prosecution described as a central plank of their case, and the judge fails to even recount the evidence, which shows that there's an inconsistency with her account that the light was on, and a matter which the prosecution relied on to say there was no doubt about it, then there must be extremely serious concerns as to the safety of the conviction. My lady, my lords, those are my submissions, unless I can assist you. My lords,
Thank you very much indeed, Mr. Taylor. We are, of course, very conscious that the appellant's team is acting pro bono, and we are always very grateful for people doing that in order to bring these matters to our attention. So thank you all very much indeed. And thank you, of course, to the Respondents' Council as well, particularly for the speed with which you have made your submissions to us. We're most grateful to you.
I must be Speedy Gonzales, the lady.
Yes. Are you indeed? Right. We'll remember that, and we'll look forward to hearing from you again in another case, perhaps. Well, thank you very much.
Thank you very much.
To everybody. The board will take time to consider what advice they will humbly tender to Her Majesty. The court is now adjourned.